Hi everyone and welcome to this video on understanding the difference between non-prosecution agreements or NPAs and deferred prosecution agreements or DPAs. These are tools used in legal cases, particularly for corporations that have run afoul of the law. But deciphering them can be confusing. Don't worry, by the end of this video, you'll be a pro. Now, imagine a company has messed up. They might have violated regulations or engaged in misconduct. Prosecutors have the option to pursue charges, but there are alternatives. NPAs and DPAs offer a way to resolve the situation without a full-blown trial. In return for cooperation and taking specific actions, the government agrees not to prosecute or delays prosecution. These agreements are commonly used in the United States, particularly under the Foreign Corrupt Practices Act or the FCPA, and by agencies like the Department of Justice DOJ and the Securities and Exchange Commission, the SEC. In the United Kingdom too, DPAs are used under the Bribery Act 2010. Think of an NPA as the lighter option. Here are the key differences. 1. No charges are filed. With an NPA, there are no formal charges against the company. It's more of an informal agreement between the prosecutor and the company. 2. No admission of guilt. The company doesn't have to admit fault or wrongdoing. Number 3. Focus on improvement, which essentially means that the NPA typically outlines specific actions the company needs to take to improve its practices and prevent future issues. This can include things like implementing new training programs for employees on compliance and ethics, conducting internal investigations to identify and address any underlying problems, strengthening internal controls to prevent similar violations. Now, a DPA is a bit more serious. Here's what sets it apart. 1. Charges filed. The prosecutor files criminal charges against the company, but agrees to hold off on prosecution. 2. Admission of facts. The company has to acknowledge some level of wrongdoing or admit to facts that could support a criminal case. 3. Conditions and penalties. The DPA outlines specific conditions the company must meet, similar to an NPA. These can include paying a fine, cooperating with any ongoing investigations, implementing compliance programs, and training. DPAs are utilized in the UK under the Bribery Act 2010, allowing companies to avoid prosecution by complying with certain conditions. From a company's perspective, an NPA is generally preferable, obviously. There's no formal blemish on the record, and they avoid admitting guilt. However, the decision depends on the specific circumstances of the case. Now, let's connect NPAs to training and awareness programs. Remember how NPAs often require companies to improve their practices? This is where robust training comes in. Effective training. By implementing effective training programs that address the identified issues, companies can demonstrate a sincere commitment to compliance and prevent future violations. 2. Focus on ethics and awareness. Training can cover areas like ethics, regulations, and best practices. This helps employees understand their responsibilities and make informed decisions. NPAs and DPAs offer alternatives to full-blown prosecutions. Understanding the difference empowers companies to navigate these situations effectively. By focusing on training and improved practices, companies can not only resolve legal issues but also build a stronger culture of compliance and ethical conduct. Thanks for joining us, folks. If you have any questions, leave a comment below, and don't forget to like and subscribe for more informative culture and compliance content. Thank you for watching.